Now I think, got it.
Perfect.
Now I think you have to press that button. Oh yeah, if you look down, it said, I didn't notice this before. It says recording, pause, stop, recording. Do you see that?
Yeah, I didn't notice that before. That wasn't.
Yeah, I didn't notice that before either. Now you have to press that.
Gotcha.
Actually, let me grab a glass of water real quick.
Yeah, absolutely. Look at this.
I'm sorry, Terrance.
Listen, hey, no, it's great. Look, I feel like we're not going to get any more authentic than these moments right here.
That's true. From the top.
From the top. Hello, everybody. This is Terrance from the City of Miami Black Police Precinct Courthouse Museum, and I have the joy and honor of having a conversation with Professor Craig Trocino. Yay! He is the director of the Innocence Clinic, Innocence Project Clinic.
Miami Law Innocence Clinic.
Miami Law Innocence Clinic. And our relationship actually came up because of the new exhibit that we have here at the museum called Guilty, Brief Not Guilty. Go ahead.
No, I'm sorry. I thought that now I see the recording button.
The recording button.
Now I'm paranoid about it.
So we have had a moment of recording. So you all are getting the second edition because we had some recording
user
errors. Yeah, but I was able to connect with Craig, Professor Craig, because of the new exhibit that we have here at the museum called Grief Not Guilty, reclaiming my time, excuse me. And that exhibit features the story and the artwork of Gary Tyler, a gentleman who spent close to 42 years incarcerated in Angola prison, wrongfully convicted, and was forced to pretty much vacate in order to be released. He was convicted of murder and was put on death row at the age of 16. And I've only visited that I want to say institution, but I don't want to follow the institution, that prison only but years ago, but it's always been considered a very volatile space. And it's had a strong representation of being a hard place to serve time. And so to know that Gary Tyler spent 42 years of his life being there just sparked a lot of responsibility to me. And so as a result of that, obviously I can't have the conversation about someone like Gary Tyler and not connect to the systems or how things are happening here in Florida, which brought me directly to the University of Miami. I had actually sent numerous emails to Professor Craig, and because of his workload, which I'm sure you guys are going to get a chance to hear about, I ended up reaching out to New York and going through the Innocence Clinic in New York and really making some strong inroads, and then obviously led me right back to And so I'm excited to have this conversation with you again, so that we can bring some light and shed some light. And, just some of the things that I want to make sure that we highlight from this conversation is what can we do as individuals? I feel like the conversation around Marcellus Williams really amplified a lot of people's awareness, excitement, and hunger of knowing more about what happens to individuals that are found not guilty, but still don't see the light of day after prison. In Marcellus Williams' case, he was still executed by the state of Missouri, even though evidence and state attorney, deemed him, innocent. And so that's where this conversation is. And then the other is just how do we maintain a awareness of these situations where the civilians or the outsiders could come in and help amplify why it's so important that these individuals, these human beings, are given the fair treatment that they deserve. And so, directly from the Innocence Clinic, go ahead, tell us.
Yeah, well, and there's a lot there, but first I want to say thank you for having me on, and thank you for reaching out to me. And I apologize for not getting back in touch with you right away. But I appreciate that fact that you reached out to me, and I cherish all the conversations that we've had since. So I hope this is a long-term association with us and the museum, and I hope it's a long-term friendship between the two of us. So I'm looking forward to the future, and I'm looking forward to this conversation. But yeah, I guess the first thing that really, I like people to know is that the idea of people being wrongfully convicted, it's a thing. It's a real thing. It happens. And we've only been keeping numbers about it since 1989, when from the advent of DNA typing and DNA exonerations. But I mean, if you think about it, just since 1989, according to the National Registry of Exonerations, there are 3,646 exonerations, and those people spent a combined 32,750 years in prison for something they didn't do. That's just since 1989. So you can think back before 1989, all the way as back as your mind wants to go, and the idea that there were wrongfully convicted people historically is all but an absolute certainty, and the idea that people were executed while they were innocent is, again, almost a certainty. Like we saw, and we know, at least, Marcellus, his case, that he was innocent. Another case out of Texas, a guy named Cameron Todd Willingham, he was executed, and then after he was executed, information came forward to establish that he very most likely did not commit the murder that he was executed for. So, put to rest in your mind that this idea of wrongful convictions is just something for television, and occasionally there's a documentary about it. It happens on a regular basis. And once the system gets you, once you get convicted, the amount of effort and years it takes to fix that or remedy that wrong is nothing short of staggering. The average amount of time somebody spends in prison before they're exonerated is about 14 and a half years.
Wow.
I've seen, I've had clients that I've exonerated who they have done 8 years, which is still a lot. But then there's gentlemen like Mr. Tyler who did 42.
Right.
And I have a client now that I'm working to exonerate him, and he's been in prison since 1964. He's the longest currently serving inmate in the state of Florida. And I've concluded he's actually innocent.
1964 is when he went in to.
He was arrested, I think, in 63. He was tried and convicted in 64.
Can you tell us just the history, like a timeline of how you became so involved? Obviously, practicing law, you could be doing a lot other things than doing what you're doing now, right? Which I don't presume pay as much as something like if you were out doing private practice.
Yeah, that's an accurate assumption with regard to the financial compensation. Well, I mean, I'll start from the end and work. It's like when I get that question a lot, and what I tell my students is, this work keeps me up at night, but it's the reason I get out of bed in the morning. Right? It's who I am. It's in my blood. This is the work I wanted. The job I have now is literally my dream job. But I didn't know that when I was in law school, because my undergraduate degree is in economics, and I went to law school and I was going to be, like a Wall Street banking lawyer. And then I did an internship my third year of law school at the public defender's office here in Miami-Dade County, and just these are my people. We think the same way. We have the same motivations, the same goals. And once I saw the systemic injustice that happens on the day in, day out of a large criminal courthouse in a metropolitan area like Miami, I couldn't look away. So I started my career as an assistant public defender. I did trials for the first couple of years, and then moved to the appellate division and have done nothing but appeals and post-conviction work since then. So that's going on 20. I've been practicing for 30 years. It's probably going on, 26 years of doing nothing but appeals and post-conviction, which is essentially what we do in the clinic. How I got into innocence work is a different story. I was in private practice. I opened up my own firm. I was in downtown Miami and doing nothing but appeals and post-conviction work. And one day, it was in 2003, and my phone rang. Well, before that, in 2003, Florida enacted its first post-conviction DNA testing law and procedure. So that meant there was a legal mechanism. If you had DNA that hadn't been tested before, there was a legal way you could walk in the front door of the courthouse and get it tested. Unfortunately, that it had a sunset provision where all those motions had to be filed by October 31st, 2003. So that created chaos, because if you didn't do it then, you could never do it. And then, then the state could destroy the evidence, and then you'd never get a chance at it. So my phone rings and I pick it up, and it's Barry Scheck, who is the founder, co-founder and co-director of the Innocence Project in New York City, which was the very, very first organization to do this type of work. And I'd met Barry a couple of times previously, and he says to me, "Well, look, we have this problem with the Florida statute. We need to challenge the sunset provision, and I need help at the Florida Supreme Court. Are you interested?" I said, "Well, tell me more." He said, "Well, it's going to be a ton of work. You're probably going to lose. Oh, and I can't pay you anything." So, what do you say to that? You don't say no to Barry Scheck.
Mm-hmm.
So I got involved, and we ended up at the Florida Supreme Court, and through a procedural process, we ended up losing, but getting exactly what we wanted. Through the process of that, we actually changed the statute.
Gotcha.
And changed the rule that got rid of that sunset provision in 2003. So now it's, when you find the DNA, you can bring the case now. And so doing that work, I tried to figure out how to get back into it, and then the position came up at the University of Miami, and I took over as director. I started there in 2012. I took over as the director in 2015, and the rest is history.
Since you've been there, how many cases have you and your team, your students, because all of them are students, is there any other lawyers that are assigned to, or is it you, the lawyer, and then the students?
Yeah, it's just me, and 8 students, and a couple of fellows that are returning from the prior year. The reason it's limited to that is because the American Bar Association has a general rule where if you have a clinic that represents live clients, that's what they call it. That's a bad term. Yeah. But actual people, actual cases, there has to be an 8-to-1 student teacher ratio. And okay. I'm the only faculty member, so I have to cap it at 8. Occasionally I will have pro bono counsel helping me. I have 2 cases now where I have 2 different pro bono counsel helping me. In the one case, he was trial counsel, so he's got a lot of historical context, and he's been very helpful. In the other case, one of my former students, went to work for a big, high-powered law firm that's worldwide, and she got me in contact with their pro bono department, and they've been fantastic helping me out with a big case in Palm Beach County. I mean, with the amount of witnesses, and it's just me, and they have the infrastructure to do a lot of this stuff, so their help's been invaluable.
When you talk about the infrastructure of, like, a public defender or defense attorneys and things like that, can you tell us the I guess the pros and the cons? Because there's this misnomer out there, and I'm going to call it misnomer, that if you get assigned a public offender, you're probably going to lose because they're not going to work. They have an excessive amount of cases. You're just one case of 80 or something like that versus getting a private, someone that's a private defense attorney that can assist you with your case. Can you talk about that?
Yeah, yeah. I mean, I started my career as an assistant public defender, and you're absolutely right. That is the perception. I mean, I remember very early in my career, I was one of my clients was accepting a plea offer, and so I don't know if you've ever witnessed that happen, but when somebody does that, the judge asks a series of questions, essentially going through the Sixth Amendment, telling you what all your rights you are waiving are. Like the right to confront witnesses, the right to representation of counsel, the right to remain silent, all that stuff. One of the questions they ask is, you're represented by a lawyer. Are you satisfied with his or her services? And so I'm standing next to this guy, and the judge says, you're represented by a lawyer. Are you happy with his services? And he said, quote, I don't have a lawyer. I just have the public defender. And the judge said, sir, the public defender is a lawyer. And he looked at me and said, oh, sorry, man. Right? It was a misdemeanor. It was a misdemeanor case. So, but I mean, that's an explanation. Like everybody thinks that, but it's not accurate, especially in my experience. Some of the finest lawyers I've ever had the opportunity to practice with were public defenders at the Miami-Dade County Public Defender's Office. Just unbelievably motivated, dedicated, hardworking lawyers. That being said, the system piles on them, right, and puts them in the position where it becomes maybe untenable to do the work in the way it's necessary to be done. In fact, Carlos Martinez, who's our public defender here, years ago got tired of that and just said, I'm going to withdraw on all these cases because we can't possibly do it, and it wound up at the Supreme Court, and they got relief from that. But that was a bold step, and my hat's off to him for doing that. But by and large, the public defenders that I know, that I've worked with, are good. Are there bad ones? Yeah, there's bad private lawyers. I mean, I'll get contacted by a family whose brother, husband, sister, son, whatever is incarcerated, and they'll say, well, I hired this lawyer and paid him X amount of money, and they told me they'd win and they didn't. So bad lawyering is bad lawyering. It doesn't matter where you happen to work. But by and large, the public defenders that I've encountered and that I know and I'm still friends with are some of the brightest, most dedicated people you'll ever come across.
And when you're working or selecting the students that you're going to work with, is it at a particular level? Have they had to have already had prerequisite classes? Because obviously these cases take a long time, and so you have to, they'll be done with school by the time that many of these cases will be done.
Oh yeah, yeah. So the way the clinic works is I have the 8 students for the entire academic year. So from August to May, I have them. But given the 8 students, it becomes difficult because I get about 40 applications every year for the 8 spots. So it's very, very competitive. I probably interview 20 of those 40 and then make horribly difficult decisions on, oh, my dog's barking, sorry. Horribly difficult decisions about, who to accept in it. I get the most amazing students that anybody could ever hope for. Dedicated, passionate, wanting to do this work. It's an embarrassment of riches, and I'm forever grateful for the opportunity to work with some of these young lawyers to be, because I mean, I almost, to a certain degree, I almost hesitate to call them students. They're young lawyers to be. Hold on a second.
Yeah, I think that anybody who's you have to be extremely passionate to work in a space where you see wrong has been done, and you're sifting, through, people's plea, sometimes their last letter of opportunity.
Hang on. So somebody's at my door, so there's going to be a minute where my bags go completely berserk.
Oh no, it's fine. I actually can't hear them.
You can't hear them barking?
Yeah. No. Really? Yeah, I think your ear cancels it out.
Oh, okay. What do you know?
Yeah. Yeah, I think you have the ear cancer. I think you got the right ear pods.
Oh,
Yeah,
okay.
yeah.
So sorry about that.
No, no. But
Where were we?
I said that it does take a very passionate, individual to read through these cases. You had mentioned in our previous conversation how many, I guess, plea you get a year from, people that are incarcerated asking, what's that number?
Hang on.
We're so excited. We get a chance to actually, if you are in Miami, we're located here in Miami, and you want to see the exhibit will be up throughout the month of February. And so just having this conversation is exciting to get the dig in on what work and how this work happens.
Sorry about that. We'll fix it in post.
No, yeah, that's why we're doing it. So
Yeah.
I was asking about the, I'm sure that it is, one of those things that it's very, emotional and taxing. You're reading these and you're getting a number of recommendations for you all to take these cases. How many do you take a year and on an ongoing process?
Yeah, it's difficult to say how many we take a year. We get 50 letters requests per month, and have gotten 50 letters of request for assistance per month since I started in 2012. And we get them every month, month in, month out. I have no idea really how they know to write us, but they do. So we're not at a loss for, we're not at a loss for work on it. And the students are the first point of contact. They read all these letters. They make decisions on whether we should go forward, request more information. All their recommendations come through me. So every piece of mail that comes in ends up getting, touched and reviewed by a student in one way or another. And then if the case is something we're going to go forward on, the students will track down the transcripts and the prior trial lawyer's file, start locating witnesses, fact witnesses, get police reports, read all that, read what happened at trial. If there's an appellate opinion that happened before, they'll read that too. And then we'll start putting, we have to sort of tear the case apart and put it back together and figure out if there's anything that we can do. And if there's something we can do, then, it usually starts with drafting a motion that gets filed in the court. And guess what? The students end up drafting that motion with my supervision. And then, and if the trial court doesn't rule in our way, then we go to an appellate court and the students draft the appellate briefs under my supervision, and so forth. So they get a wide breadth of experience from the very beginning of finding things to essentially, the highest level of appellate practice. That we have one case pending at the 11th Circuit Court of Appeals in Atlanta. And another one pending at the 4th District Court of Appeal in Palm Beach County. And the students, did phenomenal work. Of course, I always tell them, I do my clinic a little bit differently than the typical clinical professor would do. I give them a lot of agency and control over the cases, which scares them at first because they understand, and that's essentially the reason I do it, because they understand that there's a real human being on the other side of it, and that scares them because they don't want to make a mistake. But I tell them, I'm the safety net. Nothing goes out the door until I look at it. You are not going to make a mistake. I will not allow you to make a mistake. Right. So work on it, make the mistake, skin your knee, and learn from it, because it's not gonna go out without me looking at it, and we'll work through it, and we'll fix it, and we'll change it. And the learning process that way, since I started doing it that way, is at least in my view, has been terrific. So that's the way that happens. As far as you said, one of the things that you said was it's heavy work and it's emotional work, and that's absolutely true. It's absolutely true. We have to look at the worst things that one human being can do to another. It's just that our client didn't do that horrible thing. But in order to effectively represent him or her, we have to look, right? You have to see it. You have to understand what happened in order to establish that your client didn't do it. So we have to see that. So that's emotionally charged and traumatic. And then you have the idea that your client, a fellow, human being, is in, a 8 by 9 foot cage for maybe the rest of his life for something he didn't do. Right. I mean, that's like the most horrible thing one of the most horrible things you can think of is being thrust into a prison for something you didn't do. And then on top of that, sometimes we get close to their family members, right? And they're dealing with the trauma because their loved one got yanked out of their life for something they didn't do, right? And then if you take one more step back, that you have this horrible thing that happened to this victim, they got the wrong person in prison. So what does that mean? The person who did it is still out there doing it again to other people. When in fact, there's data that actually happens. So once a conviction goes wrong, the amount of victims that start piling up is exponential. For instance, I'm sure a lot of your viewers are familiar with the Central Park Five, or now as they're referred to as the exonerated five. In that case, there were five boys, and I'm using the word boys in particular because they were 14, 15, and 16-year-old boys. They were children, and they got wrapped up in this and coerced into giving false confessions against their friends. None of them said, I did it. They all said Raymond did it, Kevin did it, and so forth. And if the police had done their job right the first time in that, they would have found Mattias Reyes, who ends up being 6 million to 1 donor of the semen left behind on the victim. If they had found Mattias Reyes the right time the first time, he wouldn't have been out of prison to rape and murder a woman in front of her 4-year-old daughter, which is exactly what happened. Instead, they railroaded 4 boys into prison for a crime they didn't commit. So the getting it wrong has real consequences to everybody involved in the crime. And if we're going to be concerned about what you hear a lot of people say, well, victims' rights. Yeah, well, victims' rights, great. What about the woman who was murdered by Mattias Reyes? That should be alive today if the police would have focused on him, and they had evidence to focus on him. But they took the easy way out and coerced confessions out of children.
You brought in that exonerated five, and I know that in a previous conversation too, we talked about the new formal way of reflecting on those that have been wrongfully convicted. But and I want to, respect that the terms and because you want to be clear on how people want to be represented. I want to know if you can shed some light on the difference between being exonerated and someone like Gary Tyler, who, was forced to vacate, to take a lesser plea, and the benefits, the pros and cons to those situations.
Well, the difference is if there's an exoneration, then there's a deliberate finding that the person is actually innocent. In Mr. Tyler's situation, which happens frequently, by the way, it's essentially, it's called an Alford plea. It's a plea of convenience. He's not admitting guilt. He's just accepting the plea to time served in order to walk out of prison because the risk of trying it again is too great to do, or the state's not budging on it, and sooner or later you just have to take the win and walk out of the facility. So that's the difference of it. From a functional point of view, if I won't be involved in a case in the Innocence Clinic that I haven't already decided and concluded based on all the research and everything that I've done that my client's innocent, right? So I go into it believing my client's innocent. If there's a doubt on it, then I'm not gonna take the case, and that's happened before, where I've investigated a case for a couple of years and then got to the very end of it and conclude, I'm not convinced. There might be a reason to take that case from a private lawyer's point of view, but not in the Innocence Clinic because it's a specialized thing. So if I'm representing somebody in the Innocence Clinic and they're faced with an Alford plea, my recommendation is probably going to be, fortunately, I haven't been faced with that dilemma yet. My recommendation is probably going to be as hard as it is to take it and breathe free air. Because at some point you have to adjust your point of view on what victory is, right? And if my client is in prison for something he or she didn't do, my goal is to get them out of prison for not doing it. And if that's through an exoneration, fabulous. If it's through an offered plea like Mr. Tyler did, it's not ideal, but it's worth it. Many of your viewers might be familiar with the West Memphis Three. That was an offered plea. They ended up getting out. They didn't commit the crime, but they ended up entering a plea like Mr. Tyler did. Right.
And
so it's free. It happens frequently.
And the financial connection between the two. One, when I hear the exoneration, sometimes I hear money associated to it per year. I don't know how that's assigned. That money is assigned by the state, but it's oftentimes millions of dollars. And you hear people say, "Well, that's not enough to cover the pain and agony that they've experienced all these times." How is that brought to the forefront?
It depends on the jurisdiction. In Florida, you have to have you have to be it has to be an exoneration. So an offered plea wouldn't do it. Or like a plea like Mr. Tyler took wouldn't fall under the statute. Also, Florida has a clean hands provision. So if you've ever been convicted of anything else, even like a minor drug offense or something, when you were younger, you're exempted from the operation of the statute. If you can get the statute to work in Florida, I think it's $50,000 a year for every year you're in. Still, I mean, I don't know if anybody's going to sign up to do a stint in state prison for a year just for 50 grand. Right? It doesn't make any sense. In fact, we had our client Dustin Duty, who we exonerated in 2021, couldn't get operation of the statute because he had a silly conviction when he was 18, 19 years old, and when he was in Ohio. So he's exempt from it. But I convinced, I didn't convince, one of my former students who actually helped draft the original motion that exonerated Dustin, is now working for some big, powerful firm. And she convinced her partner to represent Dustin pro bono in a federal civil rights action. So that's pending. I mean, there's more ways. There's more ways than using the statute to get compensated. In fact, the exonerated five, that's how they got compensated. There wasn't an exoneration statute. They literally sued the city of New York in civil court.
Gotcha. If you could put a number to the amount of time, labor, intensity that your team puts together for a case, on average, what is the amount dollar wise would cost if they didn't have your team, right, working on their case? What would someone have to come out of pocket? I guess the out of pocket cost.
Let me think about that. So,
and the reason
it would be, it would be astronomical. I mean, it would be like Dustin's case, for instance. We litigated for 6.5 years. Circuit court, trial and not trial, evidentiary hearing in circuit court. We lost in circuit court, and then the first district court of appeal. And I mean, if it were to be billed like by an hourly point of view, it'd probably be hundreds of thousands of dollars.
Wow.
Yeah.
So is the Innocence the clinic is the clinic itself a nonprofit, and do you all receive donations? How do you build? I mean, obviously this is in kind, so how does that work with regards to your team?
Well, we exist on the largesse of the university and the law school, so we're a part of the university and law school, which is a nonprofit, and so they fund all of it essentially. The students are taking the class for credit, so they're actually paying to have this experience. As far as donations are concerned, if you Google Miami Law Innocence Clinic, the actual website address is really long with slashes and so forth, so it's really hard to recite. It's easier just Google Miami Law Innocence Clinic, and you'll find that page. There'll be information about the clinic and the kind of cases we take, and at the bottom there's a little button that says "Make a Gift." and you can click on that button and make a gift that goes directly to the clinic. It doesn't go to the university at large and they dole it out. If you use that button, it comes directly, it gets earmarked directly for the clinic.
How effective is during those times when Marcellus Williams, and I mentioned that many people didn't start becoming really actively engaged or aware, right? Was until almost 10 days out before his death, his murder, state of, a facilitated murder. How do we as civilians, as outsiders, get involved so it doesn't feel like if we had more time? Is it effective when we see these celebrities start posting about it and talking about it? Is it effective that we reach out to our governors? So where can you give us some this is what you can do type of things?
Yeah, well, first, it's really hard to keep, because there's 50 states, multiple jurisdictions to deal with. It's really hard to keep track of these things. I'm actively in the community, and it's hard for me to keep track of all of it. But one of the ways you can do is you can look at the Innocence Project in New York, their webpage, or the Innocence Network, innocencentnetwork.org, their webpage, or look at things on the National Registry of Exonerations, which is a compendium of all the data. They might have ongoing cases. If there's an area you're interested in, Google, like say, Marcellus is from Missouri. If you could Google Missouri Innocence Clinic or Innocence Project, you'll get a hit on something. You can look specifically in those areas because they might have publications about cases in that posture where they're looking for public support. And then letter writing campaigns, making noise about it is always beneficial. Sunlight is a great disinfectant, right? And so to a certain degree, if people don't know about it, they don't know about it. You don't know what you don't know. And when I started off, I said, one of the things that you need to put to bed in your head is that wrongful convictions don't happen. It's made up. It happens. Trust me, it happens. 32,000 years of time spent in prison for crimes they didn't commit. It happens. It's documented. But having knowledge about it allows you to, one, address it, have conversations about it, and try and do something about it. The machinery of the system is filled with inertia towards the status quo, right? So altering that inertia and changing the course of the machinery is ultimately difficult, and it takes a lot of time. Back to your previous question, how much does it, what it cost? I really, I'm estimating that. I really don't know, but I know that I have a case going on now that I've been litigating for over a decade. Same case. And it's who knows when it's going to end, because there's all the procedure is really complicated and diluted, and it doesn't make sense when you explain it to somebody. I tell my students, if you explain this to a fifth grader and they say that's not fair, it's probably not fair.
Yeah.
Right. And there's so many things in the post-conviction world that a fifth grader would say that's not fair. But we have sophisticated lawyers and bright judges who have made this unduly complicated and unduly burdensome for decades. And the procedure is just getting worse. The hurdles to clear are just getting higher. And the work is getting harder. And that's the main struggle. And now that I think about it, back to when we were talking about the emotional aspect of it, there's a concept that I've only in the past 5 years or so been hip to, and it's called secondary trauma. And I was at a conference, and somebody, one of the people there mentioned secondary trauma, and a light bulb went off in my head, and I went, "Oh, that's why I feel the way I do."
Yeah.
And so I got really sensitive to that, and now I present it to my class, right? And that's the thing, we discuss it on a regular basis. This is traumatic. Yeah, I understand it's traumatic. It's hard to look at. We can talk about it. You have peers to talk about it, and I'm really open about it, and it's working. Because I think it's also because this generation of students is more open to that
Yeah.
than the generation I came up with. You know, when I was a young public defender, you didn't talk about feelings. You know, it was like the old baseball coach: rub some dirt on it and get back out there and play.
Yeah.
Yeah, you know, and it's just, I mean, it's talking about feelings and emotions and trauma, that was weakness, and God forbid you show that. But the horrible damage it did to a lot of people, me included.
Yeah.
And I'm grateful that I'm aware of it now. You know,
Yeah.
it
That's
took
part
20
of
years, but
that's part of the exhibit is the grief part, and we talk about the 7 stages of grief and how it
mhm,
keeps coming in. Each person experiences a level of grief, from the victim, right? The victim's family, the person who's serving the time, the person who has to work on the case, um, down to the doctors and the examiners, and you have all these people. Like you say, the victim category piles up quickly under
yeah,
these situations. And I know and I think that's why we also wanted to elevate this work that you're doing and the team is doing, because we feel like it will benefit overall. Since I've been here at the precinct, it's been my responsibility and duty to elevate those area of conversations that typically get muddled over.
mhm,
Sometimes it's people just don't have the time to think about it because there's so many things to think about in a day. How do you put your efforts and energy? And sometimes you're only able to just jump in and jump back out of it. But you live in it, your team lives in it. And so I just want to thank you for that and being available for us to have additional conversations. We're hoping to have conversations with your students, perhaps in February. Thank you for bringing the network. So we're excited that we had the actual Innocence Project Network here during their conference, their symposium, and they were able to experience the museum and the work that we're doing here as well. So,
yeah. Everybody loved it. They were, you know, they were really impacted by the museum and by your presentation, your discussion of the things. And it was just it was really amazing and impactful for them. And I was happy to be able to do it. And I'm so grateful that you were able to accommodate us.
yeah,
You know, and we want, like I said, you know, we want to elevate what you're doing there, and get your story and the museum's mission out to more and more people, because it's necessary. You know,
yeah,
you know, darkness is destructive in so many ways,
yeah.
and only light and discussion can fix, or attempt to fix or change minds. Right? I mean, we've gotten rigid and polarized, and you know, opinion has been relegated to fact, and you know, the only way to change it is have an open and honest discussion about things, and about these things, and it's difficult, and it can be traumatic, but it's absolutely necessary.
I want to end with adding that AI has now become a big part of everybody's life, no matter what your career is, no matter what you doing. AI, this artificial intelligence. How has or haven't your team used AI for its benefit, and its advantages that it says that it gives? And in what way do you see it
Yeah.
happen?
You're asking the guy who didn't press the record button
Yeah.
an hour ago.
And the other guy who couldn't figure out where the record button was on there. Right.
Well, yeah, I mean, I like technology, and I've played around with AI, and I know some innocence efforts are using it,
Okay.
but I haven't used it much in innocence work. I use it for digesting long cases or long articles. I'll feed a long article into ChatGPT and say, summarize this for me. And
Gotcha.
you know, what was a 90-page article, I get, you know, three 3 pages of bullet points, and that way I can determine whether it's something I need to read more. But I haven't. Some people are putting transcripts into ChatGPT and having them summarize the transcripts, but it doesn't work really well because transcripts don't read like an article or a novel, because it's question answer, and that language format doesn't quite work with AI yet. I imagine there'll be a time when that won't be the case, which will save a whole lot of time. I do know of a organization in California that's using some AI to take data, all the data from a case and the witnesses and the scientific evidence and so forth, and putting it into AI and having it generate an initial opinion on actual innocence or not. And they've been having some, that doesn't mean that they don't go back and look for it, go back and do it. It just helps them weed out a little bit. I haven't experimented with that. I wish I had the time to experiment with it. It's kind of a catch-22, right? It would save me a lot of time, but I don't have the time to experiment with it because we're so full. I've got 2 cases in active litigation, 2 more cases where 2 more cases where I'm working with prosecutors to try and get a resolution on, and then actually 3 cases in active litigation now that I think about it. One in the 11th Circuit Court of Appeals, one in the 4th DCA, and one in Palm Beach Circuit Court. So I mean that's a lot, and we have probably 50 cases under investigation and another 150 that we can't get to yet. They're in our waiting list.
Gotcha.
Right. So, and then the letters keep coming in. So the waiting list doesn't get smaller, it tends to get bigger.
What's the longest case or the furthest back that your team have gone in order to get someone exonerated?
I mean, as far back as is necessary. I mean, the farthest back I've gone is the case we're working on now, where our client was convicted in 1964. He's the longest serving. I don't know if I mentioned this before. He's currently the longest serving inmate in the state of Florida. And based on the work of my students, we've pretty much pieced together. I mean, there's not a whole lot of information available for it because he was convicted in 1964. It was in Homestead. African-American defendant, white victim, all white jury. Lawyer gets appointed, I don't know, 48, 72 hours before the case. It's a capital case at the time, so the death penalty's in play. And 1-day trial, and it's a conviction and a life sentence. 60 plus years later, the trial lawyer's dead, the judge is dead, the prosecutor's dead, and all the files were in Homestead during Hurricane Andrew. So they're all gone. But we've been able to piece together a fair amount of stuff, thanks to the help of a reporter for the New Times, who's written a couple of articles about this. But we've pretty much concluded that it would have been impossible for him to commit the crime because he was in police custody for a misdemeanor around the time the crime happened. And it's a tragic story because he was 18, 19 years old at the time. He'd just gotten drafted by the St. Louis Cardinals to play professional baseball. And he and his friends were out at this bar in Homestead celebrating that. Wrong place at the wrong time. But nothing matches up. The victim testifies both defendants were 6'4", that they were driving a 4-door Studebaker. My client is like 5'9", and the co-defendant is 5'3". Nobody's going to mistake those guys as 6'4". They were also driving a 2-door 57 Ford, which is not a 4-door 57 Studebaker. The victim testifies that she was abducted, placed in the car, assaulted in the car, and then kicked the back door out and got out of a moving car. How do you do that in a 2-door coupe? You can't. Right. Then she identifies the 4-door Studebaker at the police station and says, that's the car because I remember the blood stain in the back seat and the dent in the driver's side door. That car is registered to somebody else who is known to have impersonated a police officer. Guess what the MO is? These guys walked up to me and said, we're police officers, get out of the car. Right. but they don't investigate that guy.
Right.
They go after mine. And
What's
the co-defendant had a real lawyer, and I'm using that facetiously and intentionally, a lawyer who had a lot of experience and had been around for a long time, and he got an acquittal. My client had an appointed lawyer, not a public defender, an appointed lawyer. So back to our conversation, maybe if he had a public defender, he'd have fared better. But he had an appointed lawyer who did absolutely nothing. And one day trial, all white jury, and he gets convicted. And then my students found out that on 2 previous occasions, he was found to be ineffective. So one of the main causes of wrongful convictions is ineffective assistance of counsel, i.e. lousy lawyer. And one of the cases he was ineffective on is he didn't effectively investigate a detective, the same detective who my client says beat a confession out of him. Right. So there's nothing that points to my client in this at all. And he's been in prison since 1964. How it's gotten to the point where nobody's looked at it that hard enough to see this for 60 years will be forever mind-boggling to me.
How did that letter come to you? Like, was that one of the ones that a student had read and then brought it to you and said,
no,
hey?
it was actually this reporter from the New Times, whose name, I mean, coincidentally, is Terrance.
Oh, wow.
Was writing an article about, I don't know how, I can't remember how he found out about our client, but was writing an article about him, and sent me an email. And he said, I'm writing an article about this, what do you think? It was during holiday break, so I didn't get the email, and I didn't respond to him before he published the article, but I got to him later and we started talking about it, and he did a second article about it, and that's how I got involved through this reporter. And he had found through his investigative reporting a lot of the information as well. And so if any of your viewers are interested, go to Google the New Times, and my client's name is Boast Laster. So if you do New Times Boast Laster, you'll probably come up with Terrance's article about it. And he did a really nice job on the piece. He actually wrote 2 pieces on it. So that's how I got. Sometimes cases come to me that way. Sometimes lawyers will bring me the case. Years ago, there's a play called I think it's called The Exonerated. Really interesting play if you haven't seen it or read it. There's like 5 or 6 exonerations cases, and the playwrights went back and they found the actual transcripts of a lot of the proceedings. So much of the dialogue in the play is words that were actually spoken in court by people, and the play is just like 5 or 6 of them on stools, and and it's really moving, really powerful. Well, community theater was doing it in Palm Beach. They called me and asked me if I would come up and do a question and answer about wrongful convictions after the play. Sure, I'm happy to. After I did it for like 3 different performances, and after one of them, a lawyer walked up to me and said, "I got a case for you." And so tell me about it. He tells me about it, and that's the case that I was talking about in Palm Beach County,
wow.
where that is Palm Beach County Circuit Court. No.
Wow. Yeah. Wow. So I feel like you're literally what you said. You are doing your dream job, because it's like a magnet. I mean, there has to be some fortitude in knowing that the work that you're doing every day that gets you out of bed is in fact the work that makes such a difference for so many people. And I think that's why this exhibit stands to be. I push so hard for this exhibit, because I feel like having these conversations from different angles gives it the ability to make it more palatable. Maybe someone's not on social media, maybe they're not scrolling, maybe they're not reading the newspaper and Terrance's article, but perhaps they'll walk into a museum and they'll see an exhibit that features something, and it'll turn on the light switch, or they hear a song, or see a play, right? So all the different angles that we can have to ensure that equal justice and equal opportunity is provided to individuals that are out here struggling to see their innocence proven. You're you're guilty into proven innocence, but I think it's really going back to, you're innocent into proven guilty.
Well, no, that's a terrific point, right? Because everybody talk to the average American, they say, well, you're innocent until proven guilty. Yes, until you're proven guilty, and
Right.
then it turns around.
Yeah.
You actually have to prove your innocence.
Your innocence.
And it not to a tip the scales innocence, definitively prove it.
Yeah.
And it's not only is it factually a high bar, but all the procedures you have to go through to even get to argue that high bar have developed over the years to make it as difficult as it absolutely possible for somebody in this position, especially since in that position, after they've been convicted and their sentence is final, there's no right to a lawyer anymore. Right. So all these folks, if they can't afford a lawyer, or they don't know to write to me or another innocence organization, they end up having to do it themselves. And they're held to my standard of knowledge, not their standard of knowledge. So if they do it wrong, it's over. And it's very, very difficult to resurrect something that's been done improperly before. Again, the procedures developed that way. And it's complicated stuff. I know lawyers who don't work in this space who get the procedure wrong. I tell my students on a regular basis, post-conviction litigation of a state court sentence, like Mr. Tyler's or all of my clients, when you get into federal court on that, because you can, it's one of the most complicated areas of criminal practice that exists. You add a death penalty to it, and as far as I'm concerned, it's the most complicated area of law practice, period.
Wow.
And I'll die on that hill.
Wow.
Because it is unbelievably complicated. It doesn't make sense. And the law is generated from cases, not necessarily statutes, and they're all over the place.
Gotcha. And again, for precedent, those are things that are set, and so you now have to meet those requirements, those prerequisites in order to even have the case heard or even plea your innocence, to prove your innocence, right?
Right. Yeah. There's this concept called procedural bars,
right?
And the state will force you to argue those for years before you even get to the merit one. For instance, without going too far afield, I litigated a death penalty case for 4 years on the existence of a staple. I'm not making that up. To the 11th Circuit Court of Appeals twice, because this is how dumb and overly form over substance the procedure is. Florida requires, if you file a motion for post-conviction relief, that the defendant has to swear to it. Like, I hereby swear that the above is true, and they have to be filed together. In this particular case, the swear to page was on top of the petition, not at the bottom where it normally is. So the court didn't count it. Right? 4 years. 4 years I litigated that it should be counted because it was there. Who cares whether it was on the top or the bottom? Right? And I remember at the oral argument at the 11th Circuit, after I finished my part, the state stands up and she says, well, it wasn't stapled. And the presiding judge looked over his glasses and said, counsel, would a paperclip have done it? And we hadn't argued legal merit one.
Wow.
4 years. And the attorney time on that, me, co-counsel, the state, co-counsel with the state, high level stuff at the 11th Circuit, it's just a waste. Why don't you let's talk about it on the merits. But that's how Byzantine and ridiculous this procedural form has gotten, where you end up doing that.
It almost feels like, it's like this tug of war to see who can actually win over time. It's like it's really a long race. It's a cross country. It's how much time you're willing before you fold, and money you have.
And it's like, I mean, not to be a complete geek, But it's, if any of your viewers have ever read Franz Kafka, the book The Trial, there's a line in The Trial that says the procedure morphed into the punishment.
Yes. Yeah.
You know,
Absolutely.
and I think about that a lot.
Yeah. Absolutely. Yeah. I'm amazed that we don't hear more, but I can also figure that most of us don't hear a lot about this, and about the work that's happening, because it would really change our mindset to a space that is not entertaining. And I think that those who find entertainment in this type of work, or those who find it intriguing to the point, do stay in it, but sometimes stay in it for the very wrong reasons. And so, um, I'm very interested in following up on the conversation. One, the reporter being Terrance. Two, the thought that this guy would have been a baseball player. Obviously, it was before I was born, but in a state where I was born, which again is Missouri, which the Cardinals, I don't know if they were in Missouri in the 1960s, but the fact that the Cardinals were a team, and just watching his whole life, it felt like, if once you were unpacking that I was reading an article, a movie or a script, because
Yeah.
it was so, and you're talking about Jim Crow era, right? We're talking about in the crutches of the Jim Crow era, when this was happening. And so, I'm going to continue to elevate. I thank you for this time. I thank you for us getting another stab at this, or go at this. I don't know if I should say stab or go at this.
I thank you for pressing the record button.
Yeah. And yeah, we'll be following up. This has been the Black Police Precinct Courthouse Museum here in Miami, Florida. I've had the honor and privilege of speaking with the University of Miami Innocence Clinic, which is spearheaded by Professor Craig and his fabulous 18 Wit Fellows, who do an amazing job. And we'll hear some more about those 8 students, 2L, 3L students, and fellows later on in the exhibit. The exhibit will be up throughout the entire month of February. You can come to 480 Northwest 11th Street here in Overtown to see the Grief Not Guilty, Reclaiming My Time. And that's exactly what we did with this particular conversation with Craig. Thank you very much, and talk soon.
Thank you. It was an honor to be here.
We got it. Now, whether I know how to stop it from recording, I think that might.
Well, it was that button, that same button where you started it. I think
Oh,
if
it
you
is?
press that, yeah, down at the bottom.
Yep, there it is.
Right. And then I don't know how that box came up, but it came up and said, it was doing something, and then it went into a folder.
And then it just gives you.
So when it comes up, keep an eye on the folder and what it's called, because it was a string of numbers.
Well, it
like
says
tag.
send a request. So I think you have to stop it.
Oh, okay.
You might have that. I just sent you the request.
Stop cloud recording. Okay.
Yeah.